presentation for our students to watch.
And the next case that we have, and the lawyers can position themselves for that, is Miller versus Department of Highway Safety and Motor Vehicles.
You got a stun belt on him over there? If he says anything, you're going to shock him? That was your case, man.
Okay. Ms. Cohen. All right. I will assume 5 minutes of rebuttal unless you tell me otherwise.
That is correct.
Okay. You may begin when you're ready.
Thank you. May it please the court?
Yes.
And I do have a, I guess, procedural issue. My heel broke on my shoe on my way over here, so if I walk a little funny, that's just because I'm trying not to fall and literally break a leg.
Judge Wallace is barefoot up here anyway.
I debated, but I'm so short that you couldn't see me, so that wouldn't work. We're here today because of an issue of statutory interpretation of Section 322.28, which is the statute which addresses these mandatory suspensions of driver's licenses when someone is convicted under 316.193, the DUI statute. And so the question is one purely of statutory construction. In order to look at that, we have to look, obviously, at basic rules of statutory construction. And the first thing that the court has to look at, as we all know, is the plain meaning of the words that are used in the statute.
They call that supremacy of the text up in Tallahassee, don't they?
Yes, sir. Yes, sir, they do.
I'm big fond of that term, aren't they?
And in doing so, though, it's not you can't look at just a line in a statute. You can't look at even just letter C in a statute without considering everything that is contained in the statute. We also cannot look at one section and render it unnecessary or meaningless.
The reason that's important here is the statute actually says the court shall permanently revoke the driver's license or driving privilege of a person who has convicted for 4 times for violation of basically the DUI statute.
Yes, sir.
And your client had 2 separate incidents.
Yes,
where
sir.
he had 2 DUI convictions in the first incident and 3 in the second. So that totals 5. So if we don't get past that first sentence, that's problematic for you, isn't it?
It is, except if you look at the exact language of that first sentence and read it in context with the language of the rest of the statute. It doesn't say has 4 convictions. It says has been convicted 4 times. And in each other section of the statute, when they talk about the number of convictions, they talk about prior convictions. They repeatedly talk about subsequent convictions. And most significantly was the amendment where they specifically stated that if you have 2 convictions on one day arising out of separate dates of offense, the legislature felt it necessary to say those count as separate convictions.
Ms. Cohen, so effectively what you're asking us to do is to interpret the statute to mean your client needed to be prosecuted and convicted on 4 separate occasions. Is that what you're saying?
Yes, sir. And I'm not asking the
The
court.
statute doesn't say anything about prosecution or the number of prosecutions. Is that correct?
It does not, but it also does not say anything about the number of convictions. It talks about being convicted 4 times. And I think the language is important, particularly when you look at the rest of the statute. It talks in terms of if there's a bond forfeiture, on a first conviction, this is what happened. For any subsequent convictions, this is what happens.
So if there is a conviction, like in this fact scenario, there were 2 separate cases, 2 separate prosecutions, and involved multiple victims in those cases. So basically what you're saying is, and the effect of that is to disregard the individual convictions against individual victims for the individual wrongs. Is that correct?
That is yes and no. Because in doing so, you're lumping together the criminal aspect of the proceedings, which imposes a sentence and a penalty. The license suspension is not a penalty. It's an administrative action taken to promote public safety, but also as set out by the legislature in its specific intent under this section to prevent repeated violations of the traffic laws. So if you look at the language that the legislature has
It's
used.
a penalty, but the purpose of the penalty is to provide added protection to the public for someone who clearly has, at least on paper, shown an issue with abiding by the law, specifically in this case, driving under the influence,
Well,
correct?
while you and I would probably agree that it is a penalty, it's a severe penalty to lose your license, from a legal standpoint, the Supreme Court of Florida has repeatedly stated, and the department even noted that in their brief, has repeatedly stated that it is not deemed a penalty, that it is deemed an administrative portion. In fact, if you look in 316.193, which is the DUI statute, it sets out all the penalties, the fines, the probation, the ignition interlock device, all the various things. It does not mention license suspensions.
So in this scenario, just so I'm following along, so if a person, we'll take it outside of your client for a second. So defendant's, soon-to-be defendant's driving, he or she is under the influence to the extent that her normal faculties are impaired, gets involved in a car accident or causes a car accident that kills 4 people in the other car. They can, 4 DUI manslaughters. I mean, there's no double jeopardy issue, I think it's clear. And so if I'm following along, they could be convicted 4 times for that single incident of a DUI manslaughter. And they're gonna, and actually, you know, it may be a moot point because they're going to score life absent a downward departure, because they're going to have 480 points on their sentence score sheet. But assuming that they're allowed not to, they're not put in prison for the rest of their lives, under your argument, I guess, correct me if I'm wrong, that would only count as 1 conviction under the license suspension statute.
It would, because if you also look at it from the other end, because the statute has to be applied equally across the board, as I think one of the examples I used in my briefs is if you hit the mailman, it's one conviction, 1 suspension. If you knock down 3 mailboxes or 4 mailboxes and you don't hit anybody, you can charge each victim who's damaged separately. That would now be a permanent
Or
revocation.
if I consecutively hit cars, 1 person in each car on my criminal day of driving, and I was charged with 4 counts of DUI manslaughter, that'll occur on the same day with 4 different victims, but in 4 different cars, that would be a suspension for life, right? Permanent suspension.
Well, now you're getting into, they've changed the statute a little, so for other reasons it would be, but it becomes the prosecution, the act of driving. If you hit somebody in Daytona and then you go into Jacksonville and it's 3 hours later, it's a separate offense. The bottom line is, if you look at the plain language of the statute, and we can talk about all kinds of not doomsday, but very bad scenarios. And I'm not saying that my client is somebody who is the best example. You know, you don't pick your clients for your cases or for the
And
law.
it's not really too far off, because your
But,
client's
right,
first
because
conviction was a 2
Sometimes
DUI,
bad facts make bad law.
2 manslaughters in 1 day.
Yes, sir, and sometimes bad facts make bad law, but the bottom line is that whatever interpretation of this statute, whatever the legislature said, and the legislature knows how to say what they want, they could have said multiple convictions with multiple victims count as separate convictions, but they didn't. They specifically stated, when they amended the statute, that separate convictions for offenses that occur for different offense dates.
Well, they could also have said separate prosecutions, back to my question, and they didn't put that in the statute.
They didn't put that either. Everything in this statute talks about sequential. Every single aspect of this statute talks about sequential actions of the driver. And this is just the license suspension. If the court said somebody's going to go to prison on a serious offense, they're going to go to jail, they're going to be off the streets, and their suspensions don't even start until they get released from prison. So it's going to be a long time, but that none of that detracts from the fact that our baseline is, what did the legislature say? And one of the cases I cited was that James decision where he was a sex offender. And he said, oh, I don't have to register. I can do whatever I want because I didn't pay my fine. So I haven't completed that part of my sentence, so I don't have to register. I can go wherever I want. And the court said, well, that's true, because the legislature could say that you have to start registering even if you haven't completed that, or write it in a different way, and I think they've since amended the statute. So we don't always get the outcome we necessarily think we should, but the bottom line is, what did the legislature say? And that's where we have to go back to each time, and that's why if you look at all of the language under 322.28, in every section, it is sequential. And if you look even under the legislative intent, it talks about the concerns about repeat behaviors, and that's how that particular section of the law is to be interpreted.
Well,
Again,
part of our job in the world of DCAs is to read the proverbial tea leaves from the Florida Supreme Court. And based upon who's on the court presently, you're basically saying to us that the court would read that statute, the court shall permanently revoke the driver's license or driving privilege of a person who has been convicted 4 times for violation of 316.193 or former 316.1931, or a combination of such sections, that the Supreme Court would say that, well, you need to go past that because clearly your client has 4 or 5 convictions. And
I'm not really sure, because you're not really going past that, because the question is, has 4 convictions, has been convicted 4 times mean versus has 4 convictions.
He has been convicted 5 times. He has 5.
He has 5 convictions.
If you asked him under oath, how many times have you been convicted of a DUI, he has judgments with multiple convictions, 2 different judgments but with multiple convictions. They're not asking how many times did you have a judgment, it's how many times were you convicted of this crime.
And I would just bring the court back, I think I have to bring this court back to the basic rules of statutory construction, which is that you have to read the statute altogether, that the legislature has amended the statute throughout the years to address issues that it believes are issues. If you look back at the first time this gentleman was in court, the department only gave him a 3-year suspension, whether that's good or bad, but they did not count it as his second, even though there were 2. So even the department didn't interpret it that way.
Let me ask
and it
you,
wasn't until later that they changed that.
Do you agree with the first DCA converted this from a cert case to a direct appeal?
Speaking of questions that you anticipate, I figured that this court was going to ask about that. I understand why they did. I think we.
Isn't it better for you that they did that?
Absolutely, in terms of standards of review. I think we should prevail either way.
Well, if it was a cert, you did get due process in the sense. Well, you got due. You're getting due process today.
Yes,
you
sir.
had notice, opportunity to say your piece, which your client did. Then they got the circuit appellate just said denied. They could have just denied it or PCA'd it like sometimes we do. That doesn't mean it's a lack of due process they didn't explain. You had your opportunity to present your case, and there's certainly the high standard of cert review would be problematic for you as opposed to what we have here today on.
For second tier, I think one of the issues we'd be having to discuss was the standard on first tier review and whether the circuit court did actually
Wouldn't it be second tier review?
This would be, but not the circuit court. So it would be a whole different argument with a lot of different angles. And reading the Gould decision that the First District Court of Appeal relied on, it's interesting because I see Judge Makar dissented from the decision that was made, but there was no discussion about whether or not that was proper or not to convert it to an appeal, because there was never any factual question. So it was always a de novo issue of the interpretation of the statute. And so in reading the Gould decision, then I would say yes, that was the proper thing for the First District Court of Appeal to do, because under that reasoning, it was not appellate in nature, on top of the fact that, which is a whole different argument about whether or not we agree that the circuit court did comply with due process.
Well, if you're on cert, because there's apparently difference between the second and fourth DCA on this issue, you'd lose on that on a second-tier cert, according to the Florida Supreme Court case in Garcia, where basically say if you have a split amongst the DCAs, that means there's no clearly established principle of law, therefore there's no cert jurisdiction, and I know that because that was my case that they addressed.
Yes, sir.
I didn't
However,
particularly care for that one either, didn't think of much, but that being said,
if you look at the Boulware decision, which
they
was,
win.
which was one of the decisions that was cited by the department, what the Supreme Court, what the First District Court of Appeal said, and then the Supreme Court recognized, but what the First District Court of Appeal said was the Fourth District Court of Appeal, in the Daniels opinion, or the Circuit Court may have applied the Fourth District Court of Appeal decision in Daniels, which was clearly on point regarding driver's license suspensions and whether it was a collateral consequence or a direct consequence. But the Circuit Court failed to apply the correct law that had already been determined by the Supreme Court in terms of whether or not it was, again, a penalty, administrative, and things of that nature. So in essence, what the First District Court of Appeal did, and then was subsequently recognized by the Supreme Court, was said that even if there appears to be a conflict, if one of those decisions is wrongly decided based on prior precedent from either your district or from the Supreme Court, then you would still be entitled to, then it would still be applying the wrong law.
Mrs.
And I say
Cohen,
I'm
you're
into
in
my
your
time.
rebuttal right now.
Yes,
Wanna
and if I can reserve.
Okay. It's Mr. Lynch, is that right?
Yes, Your Honor.
All right, sir, you may proceed.
Thank you. May it please the court.
Yes.
Michael Lynch on behalf of the Department of Highway Safety and Motor Vehicles, the appellee in the case. Both myself and my colleagues certainly agree that the issue here is strict statutory interpretation. And we both agree that to start off, Your Honors need to look at the plain language of the statute. And Judge Lambert and Judge Wallace, to your points, the statute in this case strictly states that the defendant, Mr. Miller in this case, must have been convicted 4 times of DUI before the permanent revocation provision in 322.28 2D in today's version.
Don't you have to read all the other parts of the statute under Connage and
I believe you do.
probably some paragraph out of the Scalia-Garner book that talks about doing that?
I believe you do have to consider the provision in the context of the entire statute, but certainly we disagree with the position of Jackson versus State, my colleague, that the provision at issue requires a recidivismist requirement. We do certainly believe that the plain language of the statute prevails, that so long as the defendant has been convicted 4 times of DUI, his license shall be permanently revoked.
So your clear position is, for everybody listening, if there was one case and there were 5 counts of DUI manslaughter and there was a conviction on all 5 counts, that person, based upon that one case, would be eligible for this suspension. Is that correct?
That's correct. And even if you were to change the facts slightly, even if an individual was charged in a single case from a single driving episode of 4 counts of a misdemeanor DUI causing personal injury or property damage, if that individual is convicted on all 4 counts, certainly you could say that the defendant in that case has been convicted 4 times of a DUI, of a violation of 316.193. And therefore, the statute at issue would apply, and the department, in the absence of the court doing so, could permanently revoke that individual's driver's license. That's precisely the department's position. And again, we're looking at the plain language of the statute. The plain language of the statute doesn't require separate prosecutions, as Your Honor has alluded to. It doesn't have any language requiring separate driving episodes. The only limitations or qualifications of that provision for it to apply are how many times the person has been convicted. And I believe the provision also states that at least one of the convictions has to occur subsequent to July 1st of 1982. And factually, in this case, Mr. Miller has 5 convictions. He's been convicted 5 times of DUI, arising from 2 driving episodes. 2 convictions occurred in 1987 for 2 counts of DUI manslaughter. In 1999, the defendant was convicted another 3 times of DUI causing property damage or personal injury.
From the same incident.
From the same incident. And we know from Bautista, from the Florida Supreme Court, that that is not any issue with regard to double jeopardy. So when the department receives notification from the court that he's been convicted 3 times, we can we can assume that those are valid convictions, that they're not listed on the DL record in violation of any sort of double jeopardy principle.
Not been set aside. There's nothing in the record that says they've been set aside.
Correct. And so the department looks at the driving record, which shows 5 convictions. It applies those facts to the plain language of the statute, which says a driver's license shall be permanently revoked so long as that individual has been convicted 4 times of DUI, and Mr. Miller has. In the department's brief, we cited the Pulaski case. It's a second DCA case. Factually, in that case, it's similar to our case, although it did address a different subsection of 322.28. Specifically, in that case, it was 2A2, which at the time of that decision, the provision provided that upon a second conviction occurring within 5 years of a prior conviction, the court, or in the absence of the court doing so, the department shall permanently revoke the driver's license for not less than 5 years. So in that case, the individual was arrested on a single case, as the examples that we've posed to the court previously, of 2 counts of DUI. The individual was convicted of both counts. The trial court in that case suspended the defendant's license for 8 years, pursuant to 322.282A2 for the 2 convictions within 5 years. So in Pulaski, it's an example of multiple counts, multiple convictions stemming from a single episode, and the court in that case clearly stated that those multiple counts from a single episode could be counted as separate convictions for purposes of an enhanced revocation period.
We don't have to follow Pulaski, correct?
That's correct. Pulaski would not be binding on this court. In fact, there's conflict among the DCAs. Jackson versus State holds contrary to Pulaski. Jackson versus State, which is a case cited by the appellant, in that case, there was an individual who was convicted previously of 1 count of DUI in 1 single episode. In a second episode, he was convicted of 3 counts of DUI. The trial court in that case permanently revoked the license based on the provision that we're discussing today, the 4 DUIs requiring a permanent revocation. The 4th DCA in that case read into the statute, which we respectfully disagree with, a recidivism requirement. So the court in Jackson is in line with the appellant's argument that prior to 322.282D ever being able to be applied, an individual must, on 4 separate occasions, be convicted of DUI.
So do you think we should pick a side and then certify a question to the Supreme Court, let them sort it out?
Well, respectfully, we disagree with the Jackson case, and we think Pulaski is more consistent with...
Okay, well, I'll rephrase it. You want us to vote, align ourselves to Pulaski and certify a question?
We would.
As opposed to voting for Jackson and certifying. Well, then you'd want us to certify the question, wouldn't you?
That would be our
So that'd be great deal.
Ms. Cohen, you know the direction this is going, right?
That would be our position. We believe the reading of the plain language in Pulaski was accurate. We believe the Jackson case, the court in Jackson, read into the statute language that simply does not exist. The statute has evolved over time. 2A2 and 2A3 now have language in there that would maybe seem to suggest that single episodes may be required, but we would note that the provision in 322.282D has never changed. From the time the department permanently revoked the license in 1999 to today, as we stand here today, that provision has always clearly and unambiguously stated if a person is convicted 4 times of DUI, the license shall be permanently revoked. And the facts support a conclusion in this case that the department did accurately and appropriately permanently revoke Mr. Miller's license due to the 5 convictions showing on his record. To address just some of the things that my colleague stated to the court in reference to requiring sequential actions, I would submit to the court that 322.28 as a whole does not employ a ladder type approach where if you drive once on a DUI, you get a 6 to 12 month suspension. If you drive a second time on DUI, it will increase. That's not always the case. And same as you go up the ladder. So for instance, to give an example, a driver who for the very first time is convicted of DUI is going to receive a revocation period between 6 months and a year. only in certain circumstances, if that same driver on a separate episode is convicted of another DUI, will that driver receive an enhanced revocation. For instance, if I drive in 2000 and get convicted of a DUI in 2000, and then I drive in 2010, a second episode, and I get convicted again of DUI, my revocation period is going to be the same as if it was my first offense. And so that's illustrative of this statute not employing an overall recidivism scheme, which was the position of Jackson. And to go even further, you may have a situation where, for instance, if I'm convicted of 3 DUIs from separate driving episodes, again, I may, under the certain circumstances, depending on how far apart my convictions are from one another, I may have the same revocation period as a first-time offender. And so it just goes to show that not every time you repeat the offending conduct will the enhanced revocation period come into play. And so I think that calls into question the ruling in Jackson, and it was further illustrated in the Florida Supreme Court case of Stolitz. In that case, factually, we were dealing with a defendant who had been convicted of a second DUI, which was for an offense that occurred within 5 years of a prior conviction. So the statute at play is 322.282A2. That provision would prescribe a minimum 5-year revocation. However, the court in Stolitz, the trial court, permanently revoked the license of that driver, and that driver had in fact only driven on 2 separate episodes and only had 2 convictions. And so again, I believe that Stolitz it illustrates that it's not, the overall scheme of 322.28 is not about recidivism. It contemplates more than that. It contemplates the actual harm caused in a single event. For instance, if you drive drunk, you crash into a vehicle and you cause serious bodily injury, you're looking at a minimum 3-year revocation. And again, it's just a minimum. So there is a circumstance where you drive once and you cause serious bodily injury, a court can permanently revoke you. Where there are situations out there where you drive 3 times as much, you commit 3 times as many driving episodes, and you only have a 1-year revocation. And so in total, we believe, based on the facts of this case, the trial court made the appropriate decision. We would ask this court to affirm the trial court's decision and find that the department properly permanently revoked Mr. Miller's license.
Thank you, counsel. Mrs. Cohen, you have a little less than 5 minutes. My first question out of the chute is, why should we not follow our colleagues on the second DCA in the Pulaski case?
Because if you read Pulaski, there were 2 cases that they cited in Pulaski. The Bender decision, which the issue in the Bender decision was they changed the number on the DUI statute. It went from 316.028 to 316.193. And so Mr. Bender argued, well, you can't count my other convictions on other dates because they were under a different statute number. So that clearly was not factually the same thing. They talked about the language of reading the statute. And if you read the Bender decision, they actually talk about the concern about repeat behaviors. So Bender, if you look at the reasoning of Pulaski, by citing Bender, the reasoning in their result doesn't follow what was in Bender. Same thing with Mitchell. The other decision they cited was the Mitchell opinion, but again, those were separate offense dates. He was sentenced on the same day, but those were separate offense dates. So if you look at the rationale and the reasoning in Pulaski, then you see that they came to the wrong decision. Whereas if you look at the reasoning in Jackson, they actually went through the language of the statute, which if you, responding to counsel's argument, I would start with Stolitz. First of all, it's important to understand the distinction between the authority of the department to act, because they're an administrative agency and they can only do what the legislature tells them they can do, and the authority of a court to take a different action. And correctly, a court can impose a higher suspension if there is no maximum suspension listed under 322.28. But the department cannot, and the statute very specifically directs the department that on a first conviction, they shall impose the maximum, which is a year, if the court does not. If the court does not on the others, however, and then they refer to a second or subsequent conviction, then the department must impose the minimum set out in the statute. So Stolitz does not give the department any authority beyond what it has specifically laid out in the statute, and Stolitz does not say that the department can change a suspension. And again, even using the examples that the department has given this court, clearly the legislature has chosen to make decisions that we may not agree with. We may not agree that if you get arrested 3 times for DUI and you happen to get 10 years in one day, you're back to 6 months or a year. We may not like that. We may not agree with it. But it's not our decision to make. It's up to the legislature. And so the legislature has set out how it directs the department to impose suspensions under certain fact patterns, and it includes that sequence in every one of them. And and also I think for whatever it's worth, and whether or not these were manslaughters or they weren't, really should not enter into the calculation because that's not part of this part of the statute. That part of the statute has changed altogether. So we're really talking about, like the suggestion in the example I gave, it can be hitting 4 mailboxes versus hitting 1 person, and your penalty is greater. It could be any of those things. And so taking that aside, and the other thing I wanted to add was, while we're not disputing the fact, this is not about the facts, one thing that the department noted was that the department's permanently revoked the license in 1999. As addressed in the hearing very below and in the documents that are contained in the record regarding the certified driving record and the uncertified driving record, it appears that the department actually added it to the record in 2013, which is interesting because it was about a month before the amendment to the statute where the legislature went in and specifically said separate offenses, even if convicted on the same day, count as separate convictions, but they were very clear that it was on separate days. And so I don't know if that's coincidence, if that caused an audit or what caused that, but if you look at those items in the record, which are contained, and I apologize, I thought I'd written the page numbers down for those particular items that are contained in the appendix from the original argument. Clearly, it didn't happen until 2013. I don't know what that difference that makes in terms of the discussion, but just to clarify that in terms of the facts set out. And if there's no further questions, I think that's everything.
All right,
And
thank
more.
you. Thank you, counsel. It was well argued on both sides. And Ms. Cohen, while you're up, why don't you, could you give the students a benefit of your background?
Yes, sir. I was born and raised in Gainesville, so preschool to law school. And after I graduated from the University of Florida undergrad, I went down to South Florida for a while, and I was a parole probation officer. And when I was in college and when I did all that, there were certain things that you learn about the entire criminal justice system, and that is where the power lies and how you can become involved in that. And I ended up going to law school because I wanted to be a prosecutor. Because the judges can only rule on cases if the prosecutor brings them, and the prosecutor has a lot of control, a lot of power, but you have to have the respect for the fact that you have all that power. So I was a prosecutor, and particularly I was interested in juvenile prosecution because the issue of juvenile that commit law violations, it's an issue of protection of the community, but also how do we make sure that this doesn't happen again, and how do we address whatever needs there might be for a kid, because your issues are clearly very different than adults. At one point I had a child in high school, a child in middle school, and a child in elementary school, and I was going 8 million different directions, and my current boss came and talked to me, and he said, why don't you come do appeal work in my office, post-conviction, which is after certified certain motions, come work in my office. And so while I, at the point, was like, I could never do that, that's so boring, because what my kids were doing, and because I had so many things that I was active with my kids, I went ahead and did that, and that was 20-some-odd years ago. And so I've been there ever since. And I do some of the trial work, but like the other gentleman before, a lot of the times in my office, I'm called upon if there's motions to argue, to do these appeals, to do that sort of thing. I also handle some cases from the defense standpoint for some of the trial work. And you get a very different perspective, and you, when you work both sides, and it's very beneficial to have both of those perspectives because you're dealing with human lives, whichever side you're on. So that's a little stressful. And so I've been doing that ever since. My kids obviously are grown. I actually have a kid in Seattle. And so I'm trying to think of what the other thing, in terms of getting ready for today, my brief wasn't as long because, as y'all could probably figure out, the issue was a little more narrow than the other case, and the facts were just really not as significant because there was no dispute about the facts. We agreed this is what the fact is, what does it mean under the law? So, but even with that, I took several days where I focused totally on that. Of course, my grandchildren were in Orlando on Saturday, so I did go to the water park on Sunday. But other than that, I spent several days getting ready for today. And in terms of the briefs and everything like that, you have to, even if you do a lot of it and you know stuff, you have to check the cases every time because something may change, another court may say, no, that case isn't good law anymore. You don't want to come in here and argue something and have one of these gentlemen say to you, that case isn't good law anymore. So you have to make sure that you get prepared for everything. I don't remember what the rest of that.
That's good.
Thank you, Mrs. Cohn. And Mr. Lynch.
Yes, good morning, everybody. My name is Michael Lynch. Undergrad, I went to UCF right here in Orlando. I actually majored in marketing, which my life kind of took on a complete different trajectory after undergrad. My degree was in marketing. Thereafter, I decided I didn't want to do marketing. My uncle was a lawyer, and he had told me about all the stories, cases that he's tried and clients that he represented. And I felt that it would be a career path for me that would be very rewarding, and it's exceeded my expectations entirely. And so after undergrad, I went to law school right in Orlando at Early University School of Law. I actually still reside in Orlando. I've been there since, I would say, roughly 2010. But my first job at a law school was as a prosecutor in the 18th Judicial Circuit, which is comprised of Seminole County and Brevard County. When I applied, I was hoping I'd get a job in Seminole County as I resided in Seminole County, but the only opening they had was Brevard. So for the next 5 years, I commuted to Brevard every single day for work as a prosecutor. I started off in county court where you prosecute crimes, second-degree misdemeanors and first-degree misdemeanors. So you might encounter cases where an individual driving a suspended license, has small quantities of illegal drugs, or driving under the influence, as you heard about today. Eventually, I was promoted to circuit court, where you'll handle more serious offenses that are punishable by prison time and things of that sort. It was a very rewarding experience.
What type of cases? You mean like robbery and
Yeah.
murder and stuff like that?
Exactly. When you get up to circuit court, you handle anything from, you can handle grand thefts where the individual has stolen a certain money value.
Stole a car or something like that?
Yeah, grand theft, motor vehicle, where an individual steals a car. Homicides could be anything from a DUI manslaughter, where maybe there's not an intent to kill, but you committed an act which caused the death of another individual. Or it can be a first-degree premeditated murder, where somebody had a plan, put that plan into effect, and took someone's life. So it's a broad range of cases with a very broad range of possible punishment for the individuals that are accused of those crimes. And so it's a heavy weight to have on you, but keep in mind that what you're doing is going to protect the community. It's going to have a great impact on the victim's life that you're in essence fighting for in court. It's an extremely rewarding experience. It's something that I would do again if I had to start over. And the trial experience that you get is unmatched. To be able to stand in front of a judge almost on a daily basis is certainly an experience that I would recommend to anybody interested in getting into law if you have those aspirations.
Depends on the judge, though, doesn't it?
To some extent, yes. Not everything in court's going to go your way. that's part of the job. You learn to live with it. You always do what you feel is right. Certainly as a prosecutor, you never want to mislead the court. You always want to follow the law and apply the facts that you have in your case to what the law is. Sometimes you get the outcome you want, sometimes you don't. That's just kind of the nature of the beast, as Counsel said earlier. After my career as a prosecutor, I actually had my first son. His name's Grayson, so I love your name there. I had my first son, so that brought me closer to home. I wanted to look for a job that was closer to Orlando. I was tired of staying at the office till 7, sometimes 8, preparing for trial, and then having that hour-long drive home. So in order to see my son a little more, I looked for work closer to home. I began my employment with the Department of Highway Safety and Motor Vehicles. It's a very broad department that has a number of different divisions within it. One division is the Florida Highway Patrol. I actually started my career with the department as a troop legal advisor for Troop D, which encompasses 6 different counties within Central Florida, actually including Volusia. And so as part of that job, you provide 24/7 on-call legal assistance to the members of the Florida Highway Patrol. I developed trainings and presented trainings to them just to ensure that they're doing what they should be doing. And it gave me an opportunity to employ my skills that I had learned from being a prosecutor in that criminal law world, and also kind of get some experience into the civil realm as well, doing civil asset forfeiture, where you can take property that's used in the commission of certain felony offenses or the proceeds of criminal activities. And so it was kind of my segue into.
So like if some drug dealer is found with a bunch of money, then, and that's from the sale of drugs, you guys would pursue getting that money as well as prosecuting him for committing the crime?
You would, yeah. In those cases, you have 2 separate proceedings that are kind of going on at the same time, and they're both separate and distinct. So you might have an individual who's charged with, we'll say, trafficking in some very serious drug, that when he's arrested, he's got, a sack of cash in his trunk. And the law enforcement agency will, of course, arrest the individual for whatever offense it is that they feel the facts support. And the law enforcement agency can also seek civil asset forfeiture of that cash, so long as we can prove that the drug use or drug transactions has some sort of nexus or connection to that cash. So it's not that you can just take people's property. You've got to prove that it's either the proceeds or it was used in the commission of that offense. And just like in criminal court, where that individual would have a jury trial if they so choose, in a forfeiture proceeding, again, it's basically a lawsuit against that property. The property owner has the opportunity as well to have a jury trial. We would have to prove beyond reasonable doubt, just like in the criminal case, that property was used in the commission of the offense or as proceeds of the offense. And so I did that for roughly 2 years, and then kind of found myself in this position now where I essentially defend the administrative actions of the department when it comes to suspension, revocation, cancellation of driver's licenses. And so this is one of the aspects of my job that you saw today. I hope you enjoyed the presentation. If anyone has any questions.
All right. So just counsel question to both of you. How many times, Mrs. Cohen, have you appeared in an appellate court setting such as this and argued cases? If you can estimate.
In district, I've been in the Supreme Court 7 times.
Florida Supreme Court.
Florida Supreme, yeah.
Okay.
Florida Supreme Court several times, sometimes even successfully. I've been in the First District Court of Appeal.
That's
Probably 10 to 15.
That's in Tallahassee.
That's in Tallahassee. And then on the circuit bench, in Duval County and in various counties, that's a lot.
Okay. All right.
Yeah, I'm fairly new to this. So this was my first appearance in front of the District Court of Appeals. I've never appeared in front of the Florida Supreme Court. As a prosecutor, when you practice in county court, if there's an issue or a perceived issue by one side, for instance, if an individual is convicted of a crime and the defense feels there was some sort of issue that was occurring during the trial, they can preserve that issue for appeal. And at the time I was practicing in county court, the appeal would go to a circuit court bench. So similar to what you see here, but on a circuit court level, you have a panel of 3 judges just like this, and you would trial court and then present oral argument just like we saw today, just in a different venue in front of circuit court judges. So I was able to do that twice, thankfully successfully, and this is my third appearance in the appellate court.
Mr. Lynch got his start at the 18th Circuit as an assistant state attorney. I did too. I was in Seminole County, and Mrs. Cohen was talking about juvenile court. I was assigned to juvenile court as my first assignment, and I had no children, which now that's changed. I have two of my children that are now in the gallery today, one of whom is Grayson, who asked the first question. So, yes, in my...
He's planted people in the audience to make them look good.
Yes. Yes. And my daughter, who I introduced for the first time today, not as Caroline Wallace, but as Caroline Quinlan. So that was a gut punch for me. But congratulations, Caroline. So,
She's married, not because she wanted to change her label.
okay. Somebody have a question for Mrs. Cohen?
She's going to direct.
Okay. All right, to Mr. Lynch. Go ahead.
What is the biggest case you have been a part of?
The biggest case.
Today.
Yeah. Today was a big moment just because it was my first opportunity to present argument to a Fifth District Court of Appeal. I'm thankful to be here in person. I know there was an opportunity to appear remotely, but I thought to have the full experience being in person was excellent. So this experience has certainly been a moment in my career that I'll remember. But if I had to choose a case, I would probably go back to my prosecutor years. Towards the end of my prosecution career, I tried a DUI manslaughter case. The facts were very difficult. We had a blood result in that case, so the individual was eventually arrested. Not on scene. So DUI manslaughter sometimes are a little strange. Not all the time is the individual arrested at the scene of the incident. Because sometimes law enforcement, for various reasons, will want to wait to get the blood test result back to see what the person's breath alcohol or blood alcohol content is, and whether it's above 0.08, which is the legal standard in Florida. And so there were a lot of intricacies in the case that made it very difficult in terms of proving whether the person was under the influence to the extent that their normal faculties were impaired, or that they were driving with an unlawful blood alcohol content, because in this specific case, the blood sample was taken pretty far after the event had occurred. And so there was an argument from the defense that whatever the blood result was not necessarily the blood result at the time of the crash. And so it was undisputed, obviously, that a death had been caused, but the issue and the argument in the trial was over whether the person at the time of that crash was under the influence to the extent that their normal faculties were impaired or above 0.08. And so it presented a tough challenge for us. We actually tried the case, and the first time we tried it, we got a hung jury. It was a mistrial, which means you basically get to try the whole thing over again, because we didn't have a jury come to a unanimous decision. So they would not all say guilty, and they would not all say not guilty. And so that added another level of difficulty to it, because now you've got to put this victim's family through this entire process over. And so it's sort of a gut punch to a prosecutor, because you want to do everything you can for that family, and you have this overwhelming feeling of failure because you didn't get the result that they wanted. Ultimately, that case ended up resolving short of a trial. The family, for various reasons, didn't want to go through the process again. An offer was made to resolve the case, and the defendant accepted a plea resolution. And so I would have to say that was probably the most difficult case, just because the facts were very difficult to use for the prosecution, but even more so just the feeling of maybe I could have done something different to obtain a better outcome from the family. So I would say that was probably, from a professional and emotional standpoint, probably my toughest case.
Thank you. Any question for Mrs. Cohen? Yes.
I have one for both of you, if you don't mind. What does a typical workday look for both of you, and how many hours do you think you work a week? On average.
I would suggest that my typical workday is probably very different than his typical workday. It's also just just so y'all know, nobody's asked, but we work together on a lot of cases. And on TV, you know, you see the attorneys are like at each other's, and that's just not how it really is. You know, we get along. This is actually my first time because he's going to meet him in person, but we communicate and we talk. And so we have a much better relationship. It's not like on TV where it's like, oh my God, don't trust him. But aside from that, my work day, because I do so many different things, especially now because like everything else in the world, we're short an attorney, so I'm doing a lot more court work. So I go to court in the morning and I see the judge about cases that I'm working on and trying to get witness information and things like that. And then you're talking to witnesses, you're doing research. Everything is in Duval County. Our sheriff's office has body cameras and DUI videos, so hours watching body cams and DUI videos. And then I may go and do the type of hearing like this case is related to. In the department, we go have a hearing about somebody's driver's license. And so most days run very long now. And then sometimes I have to take days and work on stuff like this. So for me, it's pretty much I'm doing a lot of different things, talking to prosecutors, doing a lot of different things. A little bit different.
Yeah, mine's a little bit easier these days, but it's still difficult nonetheless. And so I would probably say it's fair to say that my position is more of an 8 to 5 position than Mrs. Cohen's case. I come in at 8. For the most days, I leave at 5, but there are days where there's just not enough time during the day and you got to stay a little late. My day is predominantly spent researching and writing, preparing for cases like you saw today. It could be answering questions from individuals like Mrs. Cohen that are calling saying, hey, this is an experience my client had, can you look into it? And sometimes we'll look into it to kind of avoid getting to this stage if we can. That's predominantly my day is researching and writing. Every so often they will have me conduct training for the department. So when that day comes, you know, I prepare the training and present it. But most of my job is just researching and writing. I will say it's much different now than the early stages of my career as a prosecutor. When you're a prosecutor, the caseloads are overflowing. And so at any given time, you may be responsible for upwards of 150 cases. On top of that, new cases are coming in. And so you've got work while you're in court almost every day, sometimes for the entirety of the day, you've still got work coming into your office. And so oftentimes you would get out of court at 4 p.m., and you go back to your office and your desk is full of things that you have to do. And so it was not uncommon that I would find myself staying much later after 5 just to be able to get the work done and stay ahead. And so that's kind of been my experience in terms of work-life balance with the different